Global statistics on COVID-19. Currently, we have got 5.2 million people infected, positive cases of COVID-19 coronavirus. And in the past 3 months, 388,000 people have died in 188 countries. This is above the number of people who die of diseases such as HIV and AIDS, cancer, TB, malaria, diabetes, and many others. And the number of people who die daily of natural causes and accidents is staggering. Yet 90% of the people die without a will or a trust. The world has never faced death in the face before like we face right now as the result of COVID-19. We have 4 panel experts on the subject matter today who will tell us more about how to prepare ourselves and for our loved ones and when the days have come for us to go to be with the Lord. Benjamin Franklin once said, "In this world, nothing can be said to be certain except death and taxes." 2 things are known to be certain, is that we all shall die one day, and as long as we live and we work, we shall pay taxes. Even when we die, it's what we call estate duty, death tax. So you taxed until you did. In Genesis 3, verse 19, this is what the Lord said to Adam after the fall. "In the sweat of your face, you shall eat bread till you return to the ground. For out of it you were taken, for dust you are, and unto dust you shall return." If we believe the word of God that one day we shall die, we therefore ought to prepare for that day, for ourselves to go to heaven. Number 1, for ourselves to go to heaven, and for our loved ones that we leave behind to continue to live at the quality of life that they lived when we were still around. We must not leave behind hell on earth for our loved ones. We have an estate which is valuable assets like a home, property, car, pension, provident fund, cash, investments, insurance policies, debts, shares. You ought to carefully plan for any eventuality. Now I'm going to invite you to take your pen and your notebook to write down what you learn from the experts that will be presenting, and also to put down your questions, your comments, because as soon as they finish presenting, we're going to open the floor for discussion and questions and answers. So the 4 panelists will have each 15 minutes. We have an hour for them, 15 minutes. And then after that, we will have a question and answer and then proceed with our program. Our program is meant to take strictly 2 hours and we'll finish exactly at 4 p.m. So to start our program, we're going to invite Advocate Limpho Maema from Lesotho to introduce the subject and take her first 15 minutes.
Thank you, Your Excellency, and good afternoon to everyone. I'll be speaking about the basics of estate planning. And firstly, I want to start by saying often people think estate planning is for particular people, usually people who are wealthy, but estate planning is for everyone and anyone who has anything that they can leave or bequeath to any person of their choice. So we'll start with defining what is an estate. An estate is all of property, movable or immovable, and this includes financial assets, business interest, and liabilities at the time of a person's death. And this property may be jointly held, particularly for people who are married in community of property, or for people who jointly own the property, even though they may not necessarily be married. And estate planning is the process of anticipating and arranging during one's life the management and disposal of your estate. And I want to emphasize that during your life, because people often think that estate planning really caters for afterlife or after death. But even during your life, there may be life-changing events that may incapacitate you. Usually they relate to health and conditions that affect your mental or judgment and decision-making capability, in which case you would need to have someone who can make such decisions on your behalf. And this is very important, because if you do not have this at the time of such an incapacity, it will take very long for you to be assisted and to get that arrangement in place. So it's not just about death, it's also about your well-being in case of incapacitation. So an estate plan is defined as an intentional and active method of legally determining what will happen with your assets. And this includes giving property to your heirs, as well as settling of your estate taxes and debts. And the most important thing is this plan must be attested by the owner. I emphasized an intentional and active method because sometimes people think just expressing their wishes and not reducing them into writing that would constitute a legal document is sufficient. And I think with life experiences, we've heard of cases where such was the case, and it left whoever were dependents or supposed beneficiary of such estate vulnerable. Most estate plans, either a will or a trust, are usually set up with the help of an attorney, but I am aware that in some jurisdictions, financial advisors, banks, and insurance companies also provide these services, including public institutions such as the Master of the High Court, as well as non-profit organizations, usually interest groups that advocate for the rights of vulnerable groups. So it is important that when you want to start planning your estate, you engage professional help. In some jurisdictions, however, like in Lesotho, an individual can do their own will. But because of culture and religious rights, there are some intricacies that may validate such a will if no professional advice is sought, to make sure that even in the event that you make your own will, it is still compliant with legal requirements of a proper will to give it the legal force. That means it will be able to effectively protect the people you have nominated as your heirs and beneficiaries or dependents under that instrument. So why is estate planning important? First of all, it's an opportunity to create an official and legal measure that ensures that your wishes will be carried out and that they will be enforceable after you do so. So no one can annul or challenge your will or a trust. You also have control, as you can determine the terms and conditions on how the assets are to be distributed. And this you can change from time to time. It also provides security and protection for your children, parents, and other people you care about. It provides certainty and limits chances of conflict litigation, and interference by third parties and the state. The state usually does administer estates of people who died intestate, which means there was no trust or will in place. So, and this type intestate succession and management and administration of such estates takes very long and is costly as well. And it is also about being responsible and putting our affairs in order, while also assuring ourselves that we have truly done everything in our power to protect our children and loved ones. So what do you do? What are the steps involved in planning your estate? I have put up a number of things that I would call a checklist. These are not exhaustive. There may be other important things to consider as well. The first being that you need to understand the laws that govern issues around estate planning in your respective countries, because our laws differ. It's important that you do your own research before seeking professional assistance, so that you also have some basic understanding. Professional assistance comes in to now unpack everything and address the intricacies involved, but it's important that as an individual, you also do your own research regarding the options you have under the law. Secondly, you need to identify a credible and competent and reputable company or professional to assist you with your estate planning. After identifying a reputable professional or company to assist you, you should list all your assets and make sure that you have all the necessary documentation that will be required in the process. You should also list your beneficiaries, your children, your spouse, in case you are married out of community of property, and that means you would have in place an antenuptial contract, and this means that your assets, you do not own your assets jointly. Your property remains yours alone. So if you want your spouse to benefit, you would have to actively include them in your list of beneficiaries. Our parents as well, indirect dependents. And beneficiaries can also include legal entities or unborn children. In this case, it would be maybe your unborn child or your great-grandchildren and grandchildren. It's important that as you list your beneficiaries, you consider their specific needs, that is both current and future, and their circumstances to make an informed decision. Because you will find that people are at different stages and live under different circumstances. For instance, your children, when you look at your children, your youngest child has more needs than your children who have already been through varsity. So when you do allocations, do consider the person with the most needs. That would be your youngest child. And your parents, issues around disability, and sometimes really parents or owners of estates consider even issues of delinquency. So to protect the interest of the person or to protect the person from themselves, it's also important to consider how responsible a person is, and it will inform those options. So it is important that you also identify a person you trust, because part of the process is to identify people who will have the responsibility to execute your will or oversee the trust. Or if you die and your kids are still minor, you would need to appoint a legal guardian who will manage their affairs. So you need to identify a person who is of good character, and you also need to inform them to make sure that they are ready to take up that responsibility when the time comes. Next slide, please. So it's important to make sure in the process that all the necessary filings for your will and trust are completed. Sometimes things fall between the cracks, and when the tool is being implemented, it is challenged or it is found to be invalid because the process was not fully followed or completed. You need to be aware that the type of marriage affects your decision in estate planning, living arrangements as well. In some jurisdictions, if you cohabit, that person may be entitled to a portion of your estate. And also, if you are currently supporting people who are not your direct dependents, those people by law in some jurisdictions become entitled to a portion of your estate upon your death. So you need to check all these things and make sure that you exclude them if you wish to exclude them, or include them if you wish to. Ensure that you conclude whatever pending legal proceedings, or you wait for them to be concluded, because if there are any claims or you are going through a divorce, it is most likely that your estate will be affected. You also have to be careful and manage your debts and liabilities, because if you are over indebted, it means even if you have a tool in place, by the time your kids have to inherit, they may find that there is nothing really to inherit. So it's important. It's also important to inform your children or beneficiaries about this plan. Don't keep it a secret, because sometimes people keep secrets about it and nobody knows, or sometimes the executor has passed on before you, and if no one knows, then it means even that protection you had intended may not be available or implemented if the information is limited to you and the executor only. I think it's important, really, like I indicated, that everyone must take the responsibility and have their affairs in order. This is very serious. We see it in our line of duty every day. Very, very heart-wrenching cases. So let us be responsible, Your Excellencies. Go out, find out more, and have something in place for that eventuality. Thank you.
Thank you very much, Your Excellency, Advocate Limpho Maema from Lesotho. We're going to now move to Ms. Lungiswa Momoti. As we said earlier on, just write your questions down. We will take all of them at the end of each of all the presentations. So we'll have a discussions after that. We're going to call Ms. Lungiswa Momoti now to come and share her insight and experience on the subject matter. Over to you, Madam.
Good afternoon. Good afternoon to everyone. I would like to thank Global Business Roundtable for presenting me with this opportunity. I will be sharing some information about wills as an estate planning tool. So whatever I'll be saying, it will be based on the South African law. It will be based on the Wills Act, that is Act number 7 of 1953. Then it will also be based on the administration of deceased estates. I will try to make it as easy as possible. I don't want to complicate things. Firstly, I'll start by defining as to what is a will. That's where I'll be starting. So a will is any document purporting to be the will in any person's possession at any time after the death of the person who executed such document, which includes codicil or any testamentary writing. It is an expression of the testator's wishes recorded in a testamentary trust. So when we say any document, it means a codicil is regarded as a will. A codicil is an amendment to the will. It is regarded as a will. And any testamentary writing. So when the deceased passes on, it is the duty of those who are left behind to collect any document. The reason why you are saying any document, you will find out that the deceased created, the deceased maybe has 3 sets of wills. Maybe created one, let's say in 2014, another one 2016, then the other one in 2019. So each will revoke another will. So it is not within us to decide as to which will be acceptable by the master. We're expected, it is advisable that we submit all those 3 sets of wills to the master of the High Court. Then also a will has to be in writing. That's why it is said it's an expression of the testator's wishes recorded in a written testamentary. It is a requirement that a will should be put in writing. Okay, then afterwards now, let's say the testator has created this will, then he has signed the will. Then now what do you do with the will that is a document now? What you are expected to do is to keep the will at a safe, accessible place. When we speak of a safe, accessible place, like a safe place, it could be an attorney's firm, it could be a financial institution, it could be a relative that is a trusted relative. So you keep it in a safe place. Remember, a will is a precious document. It is a step to estate planning. It's whereby you deal with your legacy. So it has to be kept safe. It has to be accessible. It's pointless for a testator to create a will and end up hiding it. Once the testator is passed on, the people should be able to access it. Then now what happens upon death? Then upon death, the loved ones will have to take the document and lodge it at the master of the High Court. And lodge it at the master of the High Court. Now, which master of the High Court? It should be the master of the High Court within the jurisdiction where the deceased used to reside prior to death. Okay, let me continue. Or I was still saying the loved ones will have to take the will and lodge it with the master of the High Court within the jurisdiction where the deceased used to reside. Now the question could be, the person who's appointed as an executor won't be able to utilize the master of the High Court that is within that jurisdiction of the deceased. Then in that instance, the executor can apply to the master and ask the master to waiver for the waiver of jurisdiction. That is, now you will be applying to that master of the High Court that has jurisdiction. So okay, let me continue. Then afterwards, in some instances, you will find out that the family, maybe they conceal the will. They disrupt the will, they falsify even the will. So now what do you do in that instance? Well, there is section 102 which imposes penalties on any person who steal or willfully destroy or falsify any document that is purported to be the will of the deceased. So in other words, that section is a protection. We don't have to worry as to what if they destroy, what if they falsify the document. Okay. Then afterwards, now I'll move to a stage whereby the will has been lodged now with the master. What is the master's duty? The duty of the master is to accept, to reject, and register the will. That is the duty of the master. It's either they accept, if they accept the will, then it is favorable, because that means you will be able now to wind up the estate. Then if the will has been rejected, it will still be registered by the master, even if it has been rejected. Then what do you do if the will has been rejected? Then if your will has been rejected, then you will have you can always contest, you can always apply to the court. Section 2(3) of the Wills Act is available. Sometimes the will has to comply to the formalities. There are formalities that has been set out in the Wills Act that the will has to comply with. In some instances, you will find that the will does not comply with the formalities. Then it is rejected by the master. Then what do you do? Then you have to go to court. You can always contest. You can always you just have to go to the court. The court will use its discretion, and it depends from case to case. Also, what I'm trying to say here, if the testator had a will, then the will unfortunately has been rejected by the master, you still have another option. You can still challenge the will instead of just sitting and allowing the estate to devolve interstate. So further, it is only the court that can declare the validity of an invalid will, as I have explained, that at times the will does not comply with the formalities. Then you have to approach the court. The duty of the master is only to accept, reject, and register. Further, it is only the court that can restrain the freedom of testation. When we speak of the freedom of testation, it's the freedom of the testator into disposal of his or her property. So in some instances, you'll notice that the testator have drafted the will, but the will is against public policy. Also, maybe there's a maintenance claim whereby minors are involved. In that instance, you can always go to the court and challenge. So it is only the court that can restrain the freedom of testation. It is only the court that can declare the validity of an invalid will. Can I please have another slide? Okay, now I'm going to move to the requirements of a valid will. As I've indicated, there are set requirements for a valid will in South Africa. The first one is that the testator has to be competent. The testator has to be 16 years and be of sound mind at the time that he was drafting or she was drafting the will. Then the second one, we come to the witnesses, because now we're talking about a document that has been drafted by the testator, who has to comply with that to what I've already stated. Then now witnesses, it should be the document, the will should be witnessed by two competent witnesses who are 14 years of age and above. When we speak of competent, it's someone who is able to give evidence in the court of law. Then the third requirement now, let's say in this will, the witness, because the witnesses do not even have to read the will, they don't have to, they'll just be called in by the testator to come and witness the will. Now in instances whereby the witness has been made a beneficiary to the will, then what do we do in that instance? Then if you are faced with that, what happens there is that the fact that the witness has been made a beneficiary in the will, it will not invalidate the will, but the bequest will be void. That is, now whatever that was bequeathed to the witness will be void. Then what happens afterwards? If that bequest becomes void, then it automatically devolves interstate. Okay, then afterwards, the testator must initial each page and sign as closer to the end. That is important, it's crucial. The testator has to sign as closer to the end. Why do we say that? We are mainly avoiding any insertion of new information. That's why it says as closer to the end. Then now, then also the testator, if the testator signs in a form of a mark, what happens? In some instances, you will find out that the testator is physically impaired sometimes. Then now he still wants to create a will. Then if he is physically impaired but still able to make a mark, he can make a mark on the will, he can make a mark. Then afterwards, that the will should be signed and commissioned by the Commissioner of Oaths. Yes, by the Commissioner of Oaths. Then now, what if, because if you take about someone who's physically impaired, it might happen that he's in the hospital bed at that time, in his deathbed. Then what if the Commissioner of Oaths is not there at that particular time? Then still the Commissioner of Oaths must sign must append the certificate as reasonable as possible. So it will still be a valid will. Can I move to the next? Can you please move to the next slide? I'm finishing off now. Now I'm moving to why do we say a will is a useful tool or a useful device for estate planning? Well, it is because it keeps the testator's affairs in order while at the grave. It is a voice of the deceased. It prevents intestacy. It prevents unnecessary family feud. It avoids delays in the winding up of the estate. It gives an honor to the wishes of the deceased towards loved ones. A testator can create a trust within a will. So, as I've indicated before, it is a stepping stone towards estate planning, because that means your affairs have been planned timelessly. You prevent intestacy. When I speak of intestacy, I speak of it's either you die intestate or it's either you die testate. So if you have a will in place, you die testate. If you do not have, you die intestate, which means now the Interstate Succession Act kicks in there. It is the Interstate Succession Act. There, we're speaking of blood relatives. Some people will just crop up and challenge, then there will be delays in the estate. So having a will in place, it avoids all those problems and the delay in the winding up of the estate. Then lastly, I would like to advise that the will should be kept as simple as possible. It should not cause interpretation of intended meaning. After you've created a will, you took time, you create a will, you plan your estate, then afterwards you have this complex estate that must be interpreted by the court, that must involve judges, discretion, law, and everything. So it should be kept as simple as possible. It should not cause any interpretation of the intended meaning. So that's all I wanted to share this afternoon. Thank you so much.
I'm saying thank you very much, Ms. Momoti, Your Excellency, for this powerful presentation on why we need to do wills. And so we're gonna move straight away now to Ms. Naseega Botha, who's gonna continue with the presentation and handle other aspects. We will keep our questions for now until the end of all the presentations, and then we can take all the questions and discussions, then we'll give the panelists to respond after that. Thank you very much. Ms. Botha, if you're ready, can you take over now?
Yes, good afternoon, Your Excellency. Before we begin, I just want to take the opportunity to express what an honor it is for me to be able to present on this topic today. The area we are discussing is quite expansive. We have time constraints, unfortunately, so the topic is going to be a bit brief because of those time constraints. So today I'm going to be discussing trusts as an estate planning tool in the South African context. But before we begin, I just want to mention that it is very important that everyone bears in mind that each of us have our own unique set of life circumstances that will influence and guide our estate planning process. It is for this reason that I caution each of the attendees to consult with a professional before taking any action or any decision, especially if you're not residing within the Republic of South Africa, as each country will have its own laws and regulations regarding the topics we are discussing today. Because I practice within the Republic of South Africa, that's where my focus is going to be on today. So this presentation is going to focus briefly and highlight some key points around taking advantage and disadvantage of using a trust as an estate planning tool. So from a historical context, the concept of the trust as we know it today was imported into South African law via English law and then developed over many years in our legal system to become a mixture of English, Roman Dutch, and South African law. And it's predominantly via our court system that the law of trusts is evolving. And this is what we call the common law. Not forgetting, our legislature has also enacted an act to help regulate trusts, which we know as the Trust Property Control Act, number 57 of 1988. Yes, quite a long time ago, but it still operates today and it still sets out the essential requirements of what you need to do in order to have a valid trust. So Broadly speaking, there are two ways in which a trust comes into existence. The first one is referred to as an inter vivos trust or a living trust. So this would be created by an individual. Let me use myself as an example. So I'm thinking, let me create this trust. I'm alive currently, so this trust is going to come into existence during my lifetime. I'm going to refer to myself as the founder of the trust. I enter into a contractual relationship with the initial trustees. This contract that we're referring to, or this trust instrument, will be the trust deed. And this trust, why are we doing all of this? It's going to be for the benefit of third parties, which is going to be the beneficiaries of the trust. Now, if I can just go a little further to say that, there's a second way in which a trust will come into existence, and that will be a testamentary trust. And this was alluded to earlier by my colleague. And this is where you actually have your trust drafted in your will, and it comes into existence when you pass away. Now, if we just look very briefly at the little colorful blocks on the side, it just alludes to the structure of a trust. So what you have at the top in the red block would be the founder. The founder is the person, as we said, who started this trust, who created this trust. The founder sells, donates, or bequeaths assets to this trust. Where is all of this assets going? The assets is going to be held or housed in what we loosely call the trust, and this is the vehicle where all the assets are sitting in. So when we refer to trustees, we're referring to individuals who manage and administer those assets that are in the trust for the benefit of those trust beneficiaries in accordance with the trust deed, which sets out all the rules and regulations and the powers of what the trustees can and cannot do. Now, when I'm referring to trust beneficiaries, I'm referring to the people who are going to benefit from the trust. Those trust beneficiaries can either be capital beneficiaries, or they can be income beneficiaries only, where they only benefit from the income that is generated in that trust. Or you could say that your beneficiaries are both capital and income beneficiaries. So if I can just use a very quick example here, let's say you have a husband who is a breadwinner of the family. He has amassed a large amount of wealth. He wants to provide for his children as well as his spouse in the event that he passes away. So he decides that he's going to set up a trust, and he's going to transfer those assets into the trust when he passes away through the use of a testamentary trust, which is going to happen inside of his will. He makes his children the capital beneficiaries of this trust, and he says that his wife and his children will be the income beneficiaries of the trust. So for as long as this trust is in existence, the wife and the children will benefit from the income that's generated and will maintain them up until such time as is a happening of an event. And when, let's say, this event is the passing away of the wife, he says that, when my wife passes away, please terminate this trust. And whatever's left over, please divide it equally between my children. Then when that point arrives, then he will have the trust terminate and the children will get what's left over in the trust, and they can share that equally amongst themselves. In that way, he has provided for his wife and his children through this entire period of time for the use of a trust. Now, before we move on to the next slide, I just want to quickly mention that the trust deed can give beneficiaries a vested right, or it can give the trustees discretionary powers. When I say vested rights, I'm saying that, it's dictating to the trustees how and when somebody's going to receive a benefit from the trust, so they are a bit limited. If it's giving the trustees discretionary powers, then what it means is that the trustees have the ability to decide, when somebody's going to inherit, how that person is going to inherit, and how much that person's going to get from this trust. So if I can just elaborate on that with a bit of an example, let's say someone has set up a trust and they have 2 kids, just to be simplistic. At some point, something happens to one of the children. They either become retrenched or they're in an accident, God forbid, and they're now disabled and unable to earn an income. If you have the trust as discretionary, it gives the trustees the ability to adjust how the children or the beneficiaries of the trust will benefit. So the trustees can then say, what, the one child who's so financially able and, can take care of himself and his family, maybe we'll give him a little less from the trust, because the other child who now unfortunately is faced with terrible circumstances needs a little more. So you've given the trustee the discretion, the power to make certain adjustments, which will be in the benefit of the beneficiaries of the trust. Then finally, I just want to add on that predominantly the object of a trust, is to provide funds or assets for the maintenance of the beneficiaries. Stuff like housing, care, education, general welfare, medical care, just advancing of their lifespan. Okay, so I've listed 5 advantages of setting up a trust. There are many more, but just due to time constraints, I'm going to focus on 5 for now, just to give you an idea of how you can use a trust to benefit yourself and your family. The first point I've got as an advantage is asset protection. And what I mean by that is that trusts are mainly used by individuals to protect assets. Assets that are transferred to a trust is no longer owned by you, so you're losing ownership of that asset. What this does is, as a positive, is if you find yourself in a situation where creditors are knocking on your door, or you're facing insolvency and sequestration, if you have set up the structure correctly, and to obviously your advantage, the assets that you have placed in this trust will be protected. So even if you go into sequestration and insolvency, the assets are protected in the trust, and the fear of losing those assets you won't have to worry about. Especially, let's say, for example, it's your family home. You don't want that home to be attached and sold off for creditors. If it's in a trust, it's protected, it's secure, and you and your family, if you are beneficiaries of the trust, can still continue to obtain the benefit of keeping that family home and having protected it. So that's the first advantage I wanted to mention to you. The second advantage is pegging the growth of assets. Now, when I say pegging the growth of assets, I'm referring to assets that have the potential to increase in value over time. By transferring that asset to the trust and out of your personal estate, the value that is increasing on that asset is increasing inside of the trust and not your personal estate. The benefit of that is that you could save on estate duty and you could save on executors' fees. Why? Because executors' fees, if I just focus on that, is paid at 3.5% legislatively on the gross value of your assets. So if I use an example just to elaborate what I mean here, let's say you have 1 million rand and you want to invest this 1 million rand, but you're going to do an aggressive investment because you're trying to maximize on the income that you're going to receive from this investment. So if you take that 1 million rand and you invest it in your personal capacity, you are still enriched by the 1 million rand, plus you further enriched by all the income that you've made off that 1 million rand. So when you pass away, you may pay an increase in taxes and you may pay an increase in executors' fees. But if you have a trust and you take that 1 million rand and it's invested inside of the trust, you've reduced your estate by 1 million rand, and the income that you have earned on that 1 million rand happens all inside of the trust. So when you pass away, you can pay less on estate duty and you can pay less on executors' fees. Obviously, if you do your estate planning correctly. So that's just how you can peg or freeze growth of assets and then save yourself, a little bit of money. The third advantage that I want to touch on is access to funds as an alternative source of income. So as mentioned by my colleagues earlier on, winding up of an estate can take some time. And while your estate is being wound up, if you are the breadwinner, for example, and you left behind a spouse and children, there may be some difficulty in them obtaining maintenance because, they still need money to live while your estate is being wound up. And if they don't have cash available, then what is it that they're going to do? A trust is useful in this sense because if you have a living trust, for example, and you have liquidity in that trust and your spouse and your children are beneficiaries, that trust is an alternative source of income for them. So they can be maintained by the trust while your estate is being wound up. And they don't have to approach your deceased estate in order to look for money in order to survive, because sometimes there may be some difficulty in that you don't have cash in the estate in order to maintain them. You need to then sell an asset or something needs to be done to create this cash. Maybe all of your wealth is sitting in assets that you don't want to lose by selling them. So it's very important that you consider all of these things in the estate planning process. As a sidebar, I just want to highlight that life insurance policies as well becomes particularly useful in a case like this if you need a cash injection. So if you take out a life insurance policy, it's very important that you nominate your beneficiaries correctly on that life insurance policy, but it can also be a separate source of income in the sense that, I take a life insurance policy out for, maybe I need a few million rand. Then I say to myself, well, if I pass away, what debts do I have? What liabilities do I have? How much money do I need to settle all of that? At the same time, I say to myself, how much money is it that my family is going to need in order to take care of themselves when something happens to me and maybe in my estate, there's difficulty or delays and they need the cash in order to carry on with their day-to-day living. You can then say, you know what, I split a certain portion of my insurance policy to pay into my estate, just enough because I don't increase the estate value too much to increase my taxes and fees that I need to pay. And I can make a percentage available to my spouse so that he or she has a cash injection in order to maintain themselves while they're waiting on my estate to be finalized and inheritance comes out. And even one better than that, if you have a trust, you can put that cash injection from a life insurance policy directly into the trust. And so you can also make sure that you have, put extra funds aside for however long the trust is going to operate to take care of the beneficiaries. Because the danger is that many of us set up a trust, but we don't leave enough behind in order to make sure that for however long that trust is going to be in existence, that there's sufficient assets or cash to take care of the beneficiaries. And we don't want them to run out, before it actually is necessary. Okay, to continue, the fourth aspect that I want to discuss as an advantage to having a trust in place is when you have family members with special circumstances. Now, on many occasions, individuals create living trusts or testamentary trusts, and they want to protect or provide for family members with special circumstances. What I mean by special circumstances is maybe you have a dependent who has a mental illness or a disability, so they cannot provide for themselves, or you have minor children. You could have a dependent who has an addiction of sorts, maybe it's alcoholism or drug addiction, and so you can't give them money directly into their hands. There's a danger of doing that. Maybe it's old age, you have parents that you're providing for and you need to make sure that you have a method of making sure that they are still taken care of. But, there's a chance they could have dementia and they're not be able to manage funds. So you need to make sure you protect them. And then, one last example could be that maybe your dependents or your family members are just spendthrifty. They just can't manage money. And if you give them, maybe hundreds of thousands or million rands in their bank account, within 1 year, there'll be nothing left of the money and everything that you've worked for would have been wiped out. And those concerns may move you to want to set up a trust to protect your wealth and to still provide for those family members in this type of instance. So should you find yourself in this situation, and I'm just going to use a simple example of a single parent with a minor child. So let's say I'm a mother and I have a child who's under the age of 18, or maybe that child is still, 5 years old, 6 or very young, and I'm doing my estate plan. I'm very worried about what happens if I pass away and my child is still very young and I need to make financial provisions available to take care of that particular child or maybe children. I decide that I'm going to set up a trust, because if I do that, I can nominate people that I trust who are professionals or who have financial acumen to manage the money and the assets that I'm going to place in this trust. And so if my child is still underage and I pass away, I've protected that child firstly, and maybe I'm in a situation where the other parent is not trustworthy with funds or has remarried and has other children. And I don't want that parent, for whatever reason, if this child is going to end up in the other parent's custody, to be able to access the funds or control the funds, because I have fears, whatever fears it is that I may have. So the trust in that case, especially with a single parent and a minor child, is very useful, because you can then have this entity with the assets in it and people that will manage those assets correctly to provide for your child up until she is 18, 21, 25, 30, whatever age you feel they will be responsible to take that inheritance or the funds from the trust. And also stop another parent, for whatever reason, from controlling or accessing the assets or the cash in the trust. So I hope that helps you to understand what I mean by how useful a trust can be to protect a beneficiary or a minor child or somebody with a special circumstance.
Thank you. You have 3 minutes left, Your Excellency. 3 minutes.
No problem. The fifth and final point about advantages to a trust, and this is just to build on what I said previously, is wealth preservation. All of these things help you to preserve your wealth. You've worked very hard for your assets. You have taken a lifetime in order to grow your estate, and the trust allows you to preserve that hard work, you know, and to have continuity in the wealth so that your trust can operate for however long you feel. I mean, maybe it's until the end of time, until it runs out of, you know, assets or cash, until the happening of an event, somebody becomes 18, 21, 25 on the death of a family member. So you can set an event as to how long the trust will operate. It gives you continuity and a certain level of peace of mind that once you've passed away, you know, all of these things and all of the hard work that you've done is protected. Hopefully in 2 minutes, I can just go through the disadvantages of a trust because we have to know both sides of the coin. And here I've only listed 4 disadvantages. You know, as I said, there are many more, but because of time constraints, we're only going to focus on these 4. And the first one's going to be loss of ownership and control. Now, as I mentioned earlier, when an asset goes into a trust, you no longer own that asset. And some people don't like to lose ownership of an asset. They want to be the sole deciding factor to decide when that asset stays, when that asset goes, and what can and cannot be done with an asset. Some people don't like the fact that when it's in a trust, they now have other people who are trustees with whom they need to engage, and they need to make decisions with and take resolutions regarding the asset. They don't like to lose control, and that could be a negative for someone as to why they want to enter into the trust. The second disadvantage is the cost of establishing and maintaining the trust. So specifically with a living trust or an inter vivos trust, you have to draft and enter into a contract. And when you do that, the contract is fairly lengthy, and the contract can also, you know, go into much detail as to how this trust needs to be run. That can cost you thousands of rands in order to do that. You have to register the trust. You have to appoint trustees. You also need to transfer the assets into the trust. Now, some people unfortunately become dismayed by having to go through the process. Some people don't want to spend thousands of rands. And also at the same time, you know, and in my experience, we've had people that register trust. They went through the entire process. They have, you know, this beautiful trust set up, but they never use them. After many years, they remember, oh, I have this trust, and then they want to utilize the trust. But by that time, the trust has become dormant, and the whole purpose of setting up the trust has been lost. They've increased the estate value substantially, and now wanting to move those assets into the trust at the point where you're at becomes difficult, you know, and it can become more costly at that particular point in time. The very final disadvantage I want to bring to your attention is administrative responsibilities. Some people, they just feel it's too much work. You know, you set up a trust, you are responsible as a trustee, you have fiduciary responsibility to the beneficiaries, you have to make sure tax returns are done, whether you're hiring accountants or not. Ultimately, the responsibility is yours. You have to make sure that the books are done, financials are done. You have to have meetings, you have to take resolutions. And sometimes a negative for people is the fact that they just don't have the time or don't want to be involved in having all those administrative responsibilities. So in closing, you know, well, I see point 3, which is higher tax rates. I think if I have some time, I'm just going to touch on that. That could be a negative for people. Trusts, as far as income tax is concerned, just to quickly highlight that, is that trusts are paying tax at the rate of 45% currently, which, you know, some people don't feel comfortable with, whereas individual tax rates are at a sliding scale, and even company tax rates are less. They're paying tax at 28%. Some people don't want to pay tax at the rate of 45%. They feel, you know, a bit nervous and worried because, well, 45% is quite high. So that could be another disadvantage that they're, you know, sitting and considering. But in conclusion, because I assume I have a couple of seconds left of my 1 minute, I just want to say that trusts are very useful tools, and they can be very good vehicles to use, you know, to create a legacy, to preserve that legacy for many years to come. What you have to do is you have to think carefully, you have to be committed, and you have to set up this trust for the right reasons. If you do all of that and you take proper professional assistance, legal advice, and you really sit down and work this thing out properly, let me tell you, the amount of money that you can save and the legacy that you can preserve and pass on to descendants of descendants, and it can just go on forever, can be the most effective thing that you can actually do when it comes to estate planning. Your Excellency, I'd like to take the time to thank you for, well, it's very short, but 15 minutes nonetheless.
Thank you very much, Naseega. It was very powerful. You've summarized the issue of trust, which is a very complicated subject matter, and you simplified it. And I'm sure people have been asking questions. I've seen. We will come back to them immediately after our last speaker.
Fantastic. Thank you so much.
Thank you very much, Naseega. We're now going to move quickly to our last panelist, Mr. Malusi Mkhize, who's the legal advisor at Discovery. He will take us through his last presentation. He has 15 minutes. As soon as he finishes, we'll see if we can take 4 or 5 questions and then give the panels to respond to them, and proceed with our program with other fewer items to wrap up the program. Mr. Malusi, over to you.
Thanks for the opportunity to actually be with the GBR session. I'll tell you one thing, it's far better than cooking for the kids during lockdown. So I told them that God, I'm busy here now. So yeah, thanks for the opportunity. Once the slide comes up, you please don't freak out. It's one slide. I'm going to spend a lot of time on it because it's really a case study. So I'm going to be talking through it. So don't worry about slides coming after that. This is going to be the main slide that we're talking about. All right. First of all, thanks to my colleagues previously. They dealt with a lot of difficult concepts regarding trusts and estate planning and wills and that kind of stuff. What I'm just going to be basically doing is I've thrown a bunch of facts together just to highlight some of the things that I've come across, obviously relevant to the topic of estate planning. So what I've done here, I've just done a structure. You'll see on top, there's a company. The company is called, just giving you a bit of some facts before I go into a bit of an analysis. We've got a company called Engineering Company. It's a private company. And in this company, we have 3 shareholders, okay? The first shareholder is Mr. Naidu, who is an individual, and he owns 20% of the shares in Engineering Company. And then we have Ms. Zwane, who owns 50% of the shares in Engineering Company. And then we have the Stain Company Trust. Okay, so now the third shareholder in the company is not an individual. It's actually, sorry, it's not a trust, it's a company. It's a Stain Company Private Company, PTY Ltd. Okay, so it's a company. And in turn, that company is 100% owned by the Stain Trust. Can you see that block on the yellow? Okay, so that's the basic structure of what we have. Okay, and then just going into the notes a bit, this is very skinny. So our facts can go this way, that way, we can create them as we go. But what I've put down for now is that the first one is that Mr. Naidu. Mr. Naidu is a 60-year-old male. He's married in community of property. His eldest son works in the engineering company, okay, that we've just spoken about, whilst his second son is a medical doctor in Namibia. So his son is offshore, while his other son is working in the company with him here in South Africa. All right. Then Ms. Zwane is a 40-year-old divorcee. So she was married, she's divorced now. And out of that marriage came a daughter. She's 7 years old. Okay. And then the third shareholder in the engineering company is the Stain Company, and they hold 30%. And in the Stain Company, because remember, now we're not talking about an individual. This is a company owning shares in another company, okay? However, this Stain Company is also in turn owned 100% by the Stain Trust. Now, why this kind of structure? Could be, for example, that Mr. Stain didn't want to own the shares in Engineering Company directly. He perhaps started a company way in the past and wants the company to continue even after his death. Therefore, he's kept the company owned by trust. Okay, so that the beneficiaries, whoever the trust beneficiaries are, will continue to benefit from the shares that are owned in the Stain Company. Hopefully that makes it clear so far. I know there might be questions so long. Unfortunately, I can't take questions now, otherwise it will get complicated, but please ask questions later on. All right, the value of the company, we're just going to assume it's 100 million rands. So, so that it works out that the Stain company owns 30 million rands. Mrs. Zwane will obviously own 50 million rands, and Mr. Naidu will own 20 million rands of the company. Okay, so those are the facts very broadly. Now, remember that when we're talking about estate planning, we're looking at just, I mean, from our first speaker, as we heard, we're looking at a person's assets. That could be movable, immovable assets. There could be many things. I'm just nitpicking on a business here as one of the assets, just to demonstrate how a trust could be used, or wills, or how these relate to estate planning. And quite incidentally, the reason I also pick on the business is very often, not all the time, some people owning shares or owning a business is often their biggest assets in their estate. So it sometimes deserves a bit of close attention. All right, so let's just get into it. So if we look at Mr. Naidu, for example. All right, so we know that Mr. Naidu is a 60-year-old. Let's say he's married. Let's assume that the wife is also 60 years old. Now, his eldest son, he works in an engineering company. Let's assume also he's also an engineer. Because what often happens is in certain companies, for example, engineers, doctors, lawyers, I can't just be a lawyer or a partner in a law firm without having certain qualifications. Okay, so I'm just picking on that because you'll see later on it has its limitations on how you split that business going forward for whoever your heirs are. Okay, so now, what Mr. Naidu could do, I mean, there's many permutations here. I'm just throwing things. What Mr. Naidu could do, so for example, is say, I leave the 20% shares that I own in this company to my wife and my 2 sons. The first problem, not problem, but the first thing to remember is that Mr. Naidu is married in community of property. So straight away, by virtue of his marital regime, that 20%, which equates to 20 million, 10 million of it is already owned indirectly by Mr. Naidu's wife. So whatever, if he says, for example, I leave my shares in the business to, let's say, my sons, then he's really in effect talking about his only 50% share. So he could do that. Now, if, for example, he says, I leave my 50% share in the other 50% share to my wife, the problem is that could arise that she's also 60 years old. She might not be an engineer. So does she really want to inherit a 20% stake in a company at that age? And she's not even an engineer? Maybe not. Maybe a better option might be for her to receive funds and maybe put them in a trust so that she earns an income into her golden years. The other problem that we sit with is the 2 sons. Now, the one son is an engineer in the company, so it's easy for Mr. Naidu to say, okay, well, I leave the shares to you because you're in the business already, you understand the business, you're very well involved. However, that might also create other problems because that shareholding that he leaves to his son, who is already in the business, might create a disinheritance for the wife and for the wife and the other son. Because if he leaves a certain value of the business, the shares to the business, that means the son will take over the business. But then what does the wife get? What does the other son who's out in Namibia get? So what we could do there possibly is set up a policy. And Discovery is one of the companies, is the companies actually first to do this, where you create an offshore policy that actually pays offshore to the son in Namibia, because he's not interested in the engineering company. He's not an engineer, he's a doctor, he's a medical doctor. So you could create simply an offshore policy that pays estate duty free, because it's an offshore policy, it's not governed by estate duty laws in South Africa, and that settles that matter. And you could perhaps say to the son that's working in the company, in my will, I leave this business 50% share of my business, because remember the other 50% share is automatically owned by the wife by virtue of the marital regime in community of property. And then you could leave it that way, very cheap, very cost effective to simply say it in your will. The reason being also is that if you just say in your will, I leave this business to my sons and my sons and my wife, is that you can't split it. The son and the wife are not, the son in Namibia is not an engineer, and the wife, she's 60 years old looking to retirement, and she's also not an engineer. The son that is in here, who is an engineer, is going to have problems cutting up the business. So it's not gonna work out. So you've got to think of ways way up front of how to actually make sure that at the end this business or that everybody's taken care of. So that's just one scenario. I'm just throwing facts around. Let's look at Ms. Zwane. And I'm not going to stick on Ms. Zwane for a long time because I think Naseega, the previous speaker, has actually touched on it very well. Ms. Zwane is 40 years old and she has a daughter. Daughter's only 7 years old, which means she's a minor. Now let's assume that Mr. Naidu, which is the other shareholder, and the Stan company have said to Ms. Zwane, should you die, Ms. Zwane, or should you get disabled, whatever the case may be, we want to take over the 50% stake that you have. Now, if they take over that stake, they need to pay Ms. Zwane's estate the 50 million rands. And who does she have as a beneficiary? It's a minor child. The minor child is only 7 years old. So maybe there, the issue of a trust comes in, so you can create a trust. So there it makes sense, because otherwise the minor can't handle those funds. And then if you look across to the Stain Trust, a bit of a more complex structure. The shares are not owned. So where you see the 30%, we could have swapped it for example, Mr. Stain. Let's assume it was Mr. Stain that actually started the company. We could swap it for him, but maybe he's perhaps thinking, well, as an individual, I die. I can't live forever. So let me create a corporate. So I've created the Stain company so that this company doesn't die. Unlike Ms. Zwane and Mr. Naidu, where they'll have to think hard about how they push forward their shareholding. So Mr. Stan has decided to create a company, and the company is owned in turn by the trust. Now, maybe the reason he has done that is that he wants the trust to be involved because the trustees are perhaps maybe his wife, his brothers, or his other family members. So what they do, they're really playing an oversight role on the company in terms of how it's managed. Because ultimately what the company is really doing is an income producing asset for the trust. Because remember, under the trust, there's still further beneficiaries that will come, that will flow through. So in this example, you'll see I've crisscrossed up and down, but just to depict some ways or some points where a trust and a will may perhaps be used. And I've picked on a business because a business can often be quite a big asset in the state. And if we start talking about things like your estate duty, like for example, the previous speaker mentioned that policies can play a very vital role in sorting out a lot of these issues. So if we had to look at, for example, let's say, let's take an example of the Stain company. Should Mr. Stain, the person who actually founded the company, should he pass away, then maybe Mr. Naidu and Ms. Zwane are interested in buying that 30% shareholding that the Stain company has in the company. So what that Ms. Zwane and Mr. Naidu can do is take out a policy on Mr. Stain so that policy will pay them, Ms. Zwane and Mr. Naidu, as beneficiaries, the funds so that they can approach the Stain company to buy the shareholding out. Now, that has some tax consequences depending on how this policy is structured, if you're dealing with a corporate or a trust. And then obviously, those kind of details you'll have to thresh through while doing a consultation with your financial advisor, attorney, or whoever is actually assisting you in terms of that. So those are the facts that I've just thrown in there. Hopefully, I've created a bit of awareness.
Thank you very much. That was a powerful presentation.
Yes.
And I'm glad that you came from an angle of using individuals, company, and trust in one solution, and to indicate the effects on individuals, the effect on company, and the effect on the trust in the estate planning. So this was a powerful presentation. We're gonna take few questions, not more than 5, to from these powerful presentations that have been made by our four panelists. And it was a buffet. It was beautiful. We thoroughly enjoyed the session. Can we take the questions? I don't know if Thabang, you have noted the questions. If we've noted them, then can we, somebody ask those questions on behalf of the people in order to save time? Just top 5. If there are repetitions, we don't take the ones that have been repeated. Top 5 questions, and then we can hand back to the panelists to respond to those questions.
All right, thank you, sir. So there's a question from Moli's iPhone. The question says or reads, I have 2 questions. What happens if parents pass on without a will and they have 5 children, assets being a house and a farm that they leave behind? The case is about 15 years old. Yes, so that's the first question. So to repeat, what happens if parents pass on without a will and they have 5 children where the assets in question is a house and a farm that they have left behind? And this is a case that's over 15 years old. The second question comes from Nomvula B. The question says, okay, I presume it says, if I have a house in my personal capacity, what is the process of moving it into a trust? I repeat, if I have a house in my personal capacity, what is the process of moving it into a trust? The third question comes from Cindy Mabe. My question is, how can you protect your assets in a trust if you are over-indebted due to retrenchment or other life circumstances? How can you provide for your loved ones so that you can leave a good inheritance? So I repeat the question. It says, the question is, how do you protect your assets in a trust if you are over-indebted due to retrenchment or other life circumstances? And then the fourth question comes from Banzi. The question reads, is it best to transfer assets to a trust where it will incur transfer costs and capital gains tax? Or is it best to buy the property via trust? And what is the best way to avoid the tax burden? The last question, Mr. Nkabinde, it says, can I do a will through an affidavit from the police station and get it stored safely with a relative? I repeat, so it says, can I do a will through an affidavit from a police station and store it safely with a relative?
There's a question coming up as to say, within what time frame must an estate be wound up? Just so a question like that. Is there to wind up the estate? I think there's that question that came in there. So can we get the responses from the panelists in 1 minute each? Just quick response, 1 minute response.
Hi, Excellency. Can I go? Can you hear me?
Yes, we can hear you.
Okay, I'm going to combine, and maybe my colleagues can add extra as well. I'm going to combine 2 of the questions. The ones had referred to, if you have a house, how do I move it or transfer it into a trust? What is the process? I'm going to combine it with, is it best to transfer assets into a trust, considering there's things like transfer costs and that kind of stuff? You know, back in the day, it used to be, and in fact, Naseega mentioned this, estate picking is very important. And we must definitely consult around that area about what and when to do it and what the effects of it are. But when you meet someone and they say, is it simply a good thing to transfer it? I think the first thing is you've got to ask, why are you transferring it? You remember in the previous speaker's presentation, the purpose of forming a trust, because you might find that things like your transfer costs, your CGTs, there's a whole lot of other things, donations, tax that could creep in. So it could be very costly to even transfer the assets into a trust. So you're probably looking at doing it for other purposes rather than just say, I'm just purely doing an estate picking exercise. Because give you an example, if I transfer my house from my hands, which was in my estate, and now I'm giving it into a trust, which is a separate entity, in inverted commas. So therefore the disposal attracts CGT. Now, if I have a house today, should I actually just move it into a trust? Well, maybe not. Maybe those costs will be a hindrance. In terms of process, I will first rather answer that question: should you even be doing it, and what is the purpose? And then in process, and maybe one of my colleagues can touch on it a little bit better. Thanks.
Thank you very much. Is it not better to actually buy properties in the name of the trust right in the beginning, rather than buy them in your name and then transfer them late when the values are high? So it's always better to create a trust early and move the values there early in life, so that when the value appreciates, it's already in the trust. So you don't attract a high transfer costs when you do so. But I'll give to other panelists to come in. That's just my small contribution to that.
Yes, if you have that choice and that option, then yes, it would be good to do that. Many people have already purchased homes, that's their primary residence, and now they want to transfer it over into a trust. If you have the ability to buy it in the name of the trust, yes, it will save you, because if you buy it in your own name, you're going to have that transfer to your personal capacity. And then later on, when you want to put it in the trust, you're going to have to pay for another transfer. And like my colleague said, the disposal of the asset, which will attract the capital gains tax, to get it to go over to the trust. So if you have the ability to purchase it directly in the trust, and you know this is maybe an investment asset, or it's a capital asset that you don't intend to buy and sell and trade, and it's just something you're trying to preserve, then yes, with that ability, I would say do it inside of the trust, because you're trying to utilize this asset to create a legacy for yourself and for your family.
Thank you very much, Your Excellency. Other Excellencies? Madam Limpho, Momoti?
Okay, can you hear me?
Yes, we can hear you.
Okay, so let me tackle, I think it's 3 questions. The first one is parents passed on without a will, 5 children. I think they left a house on the farm, and it's been 15 years. So there the estate can still be reported, regardless that they passed on 15 years ago. All estates should be reported to the master, and there's nothing they can actually do in that house. Like they can't transfer the properties without having reported the estate. So they now will be talking of 2 estates, because it's the mother and the father. Even if they were married, their estates will be winded up separately. And it will only be winded according to the Interstate Succession Act, because there was no will in place. So the 5 children will all benefit. They will just have to follow the act. It states everything, like Section 1, the spouse, then the descendants. So they can still report the estate. Then I'll move to the second question, where it is said, can I make an affidavit? Yeah, a will in a form of an affidavit, and keep it for safekeeping with a relative. There, it is not even necessary to go as far as making an affidavit. If, when I was doing my presentation, I said that a will is a written document purported to be the will of the deceased or the testator, whichever. So there is no need to go to the police station. If he wants to draft the will, to create the will on his own, he can create it, make sure that it does comply with the formalities, as I've stated, the formalities of a valid will, because the will must still be valid. So safekeeping with the relative, it is not a problem, that one, as long as it is kept safely. Then the last question on the time frame for winding up the estate. With that one, it depends on the complexity of the estate, because when you wind up an estate, firstly you start with the advert for creditors, which takes about 30 days. Then afterwards, if there are no creditors that are coming forth, then you continue, you launch the account, you do everything, then launching the account and advertisement, that we're talking about 21 days. So roughly it can take 3 to 4 months if it's a straightforward estate. There is no fight, there is nothing. So it depends really on the complexity and the beneficiaries, whether they are cooperative. It depends. Then usually, that's why we always advise clients to have wills in place. When there is the will, it makes things a bit easy. There is no fight, there is nothing like family feud, all that stuff. Thank you so much.
Who qualifies as the beneficiaries in terms of the intestate succession? Can adoptive children, stepchildren, children born before marriage benefit from the estate? Or is it only children of the person legally married at the time that benefit?
No, sir, all the children, they do qualify. When you speak of adoption, should be legally adopted. Legally adopted blood relations. That's what the Act states. So it's not.
You have to go through. You have to go through an adoption process for them.
Yes, sir, legally adopted. The Act is clear regarding that.
Okay.
When you've, just to add on to that, when you've legally adopted a child, that child is now considered to be your child, as if that child was born to you. And that child is no longer considered to be the child of the natural parent. So with a legal adoption, you've taken on that child as if you had given birth to that child. So with intestate succession, that child will be included with the other children that you may have naturally given birth to, as forming part of receiving a portion of the estate.
Is that applicable to step children as well, or they need also to be legally adopted for them to benefit?
Stepchildren, I would say, needs to be legally adopted, or you need to draft a will where you specifically give that stepchild something from your estate, because as the step parent, you are not under a legal obligation to maintain that stepchild, which the natural parents are under an obligation to do so. So without a will and without having legally adopted a stepchild, they won't automatically be able to inherit from you in an intestate estate.
Thank you very much for those powerful inputs, responses to complex questions. And I think our listeners and our viewers and our attendees have benefited a lot from this session. It was designed for that. As we said when we started, that COVID-19 is here, people are dying, and people are dying of other ailments every day, whether it's cancer, diabetes, HIV and AIDS. Most of the time we leave things in shambles. And because we think we're gonna live a long time. So this session, I'm sure, did help us think about that potential eventuality. God himself said to Adam, dust you are, and unto dust you shall return. In other words, he was saying, for you, it's guaranteed death, that you will die. So we have to stay ready and sort out our affairs so that our loved one do not get affected. I'm gonna give now, we've got the last few minutes to wrap up our session. I'm gonna give Thabang 2-3 minutes to make announcements.
All right, so the first announcement to say that today's session was proudly sponsored by Mbilo Capital. It's a fiduciary services provider that specializes in wills, trusts, and estates. So in order for you to get more information and to get a free consultation, please visit www.mbilofiduciary.com. or you can call +2711 242 8000. And as the convener mentioned, we are going to be having these sessions every week. So the next session will take place next week, which is the 30th of May, 2020. It will be taking place here on Zoom. So you're all encouraged to invite other people that can benefit from the powerful information that is being shared here. And there is translation that's taking place. As a global institution or organization, we have members that exist in Francophone speaking country and Lusophone and so forth. So translations are happening in the other channels of this session as well. And also please note that due to COVID-19, our global events have been postponed until there's further developments to the situation. So we presume that we might proceed with our global events towards the end of the year, if not next year. So please do take note of that. And then just another reminder that our programs still continue to play weekly on multiple TV and radio channels as well. And the last one is that on Wednesdays, the institution continues to fast. And for all those who would like prayer items, please visit our website. The institution website is www.globalbusinessroundtable.com. Thank you, sir.
Thank you very much. Mr. James Mabunza, Eswatini, if you can do a quick offering.
It's a pleasure to be part of these sessions and to enjoy these insightful presentations. Thank you so much indeed, and good afternoon to all excellencies. I'll be quite brief, like the convener has already laid a very good foundation for our giving. I just want to perhaps touch on two things. When giving to the poor, which is the mandate for the GFFJ, when giving to the poor, we fulfill the scripture in Matthew 35, which is very fundamental to the mandate of the Global Fund for Jesus. Matthew 25, verse 35 and 36, which says, "For I was hungry, and you gave me something to eat. I was thirsty, and you gave me something to drink. I was a stranger, and you invited me," etc. So that's number one. So we fulfill that scripture, and it is important for us to focus on things that please the Father. And in fact, when we give, it is also more blessed to give than to receive. One person that realized the significance of giving or of blessings, of receiving blessings, was Jacob. You will recall in Genesis, when he was just about to meet his brother Esau, he was very concerned. But he met this man that he wrestled with. And he said to the man, when it was just about daybreak, he says, "I'm not going to let you go before you bless me." So he realized the significance of receiving a blessing. If we want to take our own blessings, Your Excellency, this afternoon, let us give. Let us be like God, who gave us the example of what it is and the significance of giving. So if we want to take our own blessing this afternoon, let's just give. We can receive a blessing from someone else that says, "I bless you," but it is more blessed to give than to receive. So let's take that opportunity to give. We can go to the Global Fund for Jesus website for account details, so that we can then give from that platform. But can I pray very quickly for blessing and receiving the giving, the donations, etc., that you are going to give this afternoon, Your Excellencies? Father, we thank you for the giving that we are receiving on your behalf into the Global Fund for Jesus. We give you praise and honor, and thank you so much for the excellencies that are taking their time to receive, to give, in order to demonstrate their likeness with you. And we want to thank you because we know this is in your will. In Jesus' name, amen.
Amen. Thank you very much, Your Excellency. You can go to the Global Fund for Jesus platform. It's gffjplatform.com. gffjplatform.com. When you get in there, you can donate online through that platform to the Global Fund for Jesus. Thank you very much. We now go to Kenya, Ms. Saramuni, for the vote of thanks. And if Dr. Pierre Gomet from Gabon can prepare himself to do a closing prayer after the vote of thanks from Kenya.
Thank you very much, Excellency Convener. I hope you can all hear me.
Yeah, we can hear you clearly. We can hear you clearly, Your Excellency.
Thank you very much. So I want to salute you all in the name of our Lord Jesus Christ. Greetings from Nairobi. And thank you very much, Excellency Convener, for hosting such a wonderful session. We have learned a lot. Right? So sure. It's good. You know, the word of God says in the book of Proverbs that give instruction to a wise man and he will be wiser. So we are already wise to be here. But now that we know we've been taught this topic, this is spoken of topic of estate planning, I believe we are wiser. So I first of all want to thank each one of us who has logged in. Please, we appreciate you very much. We have members. GBR has membership in over 80 countries, and we have our delegates logged in from across the world. So we want to thank you very, very much from whichever country that you are from. Thank you very much. We appreciate you very much. And then we also want to thank our speakers, our panelists who've done a very good job of sharing their expertise in this very important topic. Madam Dimpo, you've done justice really in this, and especially explaining to us the basics of estate planning, really. And very importantly, you mentioned it's important even as we engage professionals like lawyers and fiduciary agents. It's important that we know the laws, we have the understanding of the laws that guide estate planning. That was very important. And then also, Excellency Lungiswa Momoti, you give very impressive presentation on the importance of having wills. It's very important. Most people do not know or have an understanding that's not very good about writing wills. So thank you for breaking down that for us. We really, really appreciate your expertise and your time. We don't take it for granted. God bless you, Excellency Dimpo and Lungiswa very much. Then Excellency Naseega Botha did a very elaborate presentation on trusts, looking at trusts as estate planning tools. I mean, very important. And some of the issues, some of the things that we really need to look at if we are going to consider having, looking at trusts as an estate planning tool. Very important and very elaborate there. We really want to thank you very, very much. Thank you so much for that. And then Excellency Malusi Mkhize, thank you for that case study. It has really helped us understand much better the importance of this topic, estate planning. We really appreciate your effort once more, and may God bless you very much and add unto your giving, because you've given the knowledge, you've shared the knowledge you've given. So we want to thank you very, very much. And even from our speakers, I want to thank the logistics team that has organized this seminar. We have the media and communications team, Excellency Tabang and your team. You've done fantastic job. We've been seeing the flyers everywhere. So thank you very much. And together with the graphics team, also fantastic job. God bless you so much. We have also the team. We have the communications team, logistics. Yeah, and thank you also, Excellency from Eswatini, for that, for speaking to us about GFFJ. We really appreciate. So, Excellency Convener, thank you very much for hosting this seminar, and we'll continue learning even next Saturday. This is very important. We keep ourselves, we keep learning, and this is a very good platform for us to learn and actually get this knowledge. And of course, finally, we want to thank the one who makes all things happen, the Almighty God, because man makes plans. One of the things that I have learned during this pandemic is that man makes plans, but you know, it is the purposes of the Lord that are established. So now, because we have had the session very well, we thank God because He's been with us. So we give all glory and honor and power and strength and blessing to the Lord, and even for keeping you healthy and of sound mind at this time. God, you know, we really thank the Lord so much. So we thank all of us, and we really look forward to see you in the next session. God bless you so much. I think I'll take it back to Excellency Convener or Excellency.
Thank you. Thank you very much. Thank you very much for that vote of thanks to all the panelists and the participants on the program. Just before we take a closing prayer from Dr. Pierre Gomat, the presentations are available on the GBR website, www.globalbusinessroundtable.com. www.globalbusinessroundtable.com. You'll find all the presentations that were made today by the panelists. So, Dr. Gomat, are you there? Are you ready to close with a prayer?
Merci, Excellence,
Yeah.
Convenant. Merci également à tous les panélistes. C'est toujours un très grand plaisir.
Hello, Your Excellency.
Merci également à Sarah Muni, à Tabang et à toute l'équipe qui font un excellent travail. Et nous allons présentement prier pour que Dieu fortifie davantage GBR et nous amène encore à une élévation plus grande. Père Céleste, je veux te dire sincèrement merci pour ta grâce et pour ton amour. Nous avons eu des très bons panélistes ce soir qui nous ont développé un merveilleux sujet sur l'héritage. Sur l'héritage, nous avons été très édifiés. Et nous prions qu'ils soient tous, autant qu'ils sont, bénis dans le nom de Jésus. Bénis très richement le convenant et tous ceux-là qui ont participé à ce merveilleux travail. Donne-nous d'avoir davantage la force pour le royaume. Merci infiniment pour toutes choses. Prends soin également de nos familles et laisse-nous toujours travailler avec l'Esprit Saint. Nous voulons te donner la gloire et l'honneur à jamais. Dans le nom de Jésus-Christ. Amen.
Amen.